evening, attorney. Good evening, classmates. Hoping we had introduced ourselves well enough. Our report will be on the Southwest Africa cases. This case will be presented into three parts, and I will be discussing part 1. Before I discuss the first advisory opinion, let me give you a background of German Southwest Africa and South Africa. And we give also a brief discussion on the mandate system. Southwest Africa was the name for modern-day Namibia and was a colony of the German Empire from 1884 until 1915. Thus the name German Southwest Africa. Now, when the First World War broke out sometime in 1915, South Africa captured the German colony. And after the war, it was declared a League of Nations Class C mandate territory under the Treaty of Versailles, with the Union of South Africa responsible for the administration of Southwest Africa. Southwest Africa remained a League of Nations mandate. What is the mandate system? The mandate system originated in the decision taken at the Paris Peace Conference right after World War I. In 1920, the League of Nations was founded, and its mandate, referring to the legal status for certain territories transferred from the control of one country to another following World War I, or the legal instruments that contain the internationally agreed upon terms for administering the territory on behalf of the League of Nations. It was agreed that the colonial territories over which Germany renounced all her rights and titles should not be annexed by the Allied powers, but should be placed under an international regime wherein territories deemed not yet able to stand by themselves by Article 22 of the League Covenant should form a sacred trust of civilization. The best method of giving practical effect to this principle was that the tutelage or guardianship of such people should be entrusted to advanced nations who are willing to accept it. And it was added that it was to be on behalf of the League, that this guardianship should be exercised by those nations as mandatories. Now, what happened after World War I to Southwest Africa and South Africa? In short, after the war of 1914 to 1918, this territory, the Southwest Africa, was placed under a mandate conferred upon the Union of South Africa, which was to have full power of administration and legislation over the territory as an integral portion of the Union. The Union government was to exercise an international sanction of administration on behalf of the League, with the object of promoting the well-being and development of the inhabitants. This refers to the 1920 mandate of the League as stipulated in Article 22 of the Covenant. Then came World War II, and the mandate continued until World War II and up to the collapse of the League of Nations. Sometime in 1946, the League of Nations was disbanded. Its powers and functions had been transferred to the budding United Nations. The United Nations inherited the powers and functions of the League of Nations. Now recall the mandate system established by the principal allied and associated powers in conjunction with the League of Nations under Article 22 of the Covenant was replaced after World War II by the International Trusteeship System established under Chapters 12 and 13 of the United Nations Charter. The new system distinguished between two classes of trust territory: ordinary trusteeship under authority of the UN General Assembly and strategic trusteeship under the authority of the UN Security Council. After the Second World War, the Union of South Africa, alleging that the mandate had lapsed since the League of Nations was disbanded, sought the recognition of the United Nations to the integration of the territory that is the Southwest Africa, in the Union. Now, the United Nations refused their consent to this integration and invited the Union of South Africa to place the territory under trusteeship, according to the provisions of Chapter 12 of the Charter. Now, the questions concerning the international status of Southwest Africa then had been referred for an advisory opinion to the court by the General Assembly of the United Nations in 1949. The following issues or questions were then brought to the court. First, does the Union of South Africa continue to have international obligations under the mandate for Southwest Africa? And if so, what are those obligations? Second, are the provisions of Chapter 12 of the Charter applicable to the territory of Southwest Africa? Lastly, does the Union of South Africa has the competence to modify the international status of the territory of Southwest Africa? Where does the competence rest to determine and modify the status of the territory? To answer the first issue, yes, the court ruled that the Union of South Africa continued to have the international obligations resulting from the mandate, including the obligation to submit reports and transmit petitions from the inhabitants of that territory, supervisory functions to be exercised by the United Nations, and the reference to the Permanent Court of International Justice to be replaced by reference to the International Court of Justice in accordance with Article 7 of the mandate and Article 37 of the Statute of the Court. The international obligations assumed by the Union of South Africa were of two kinds. One kind was directly related to the administration of the territory and corresponded to the sacred trust of civilization, referred to in Article 22 of the Covenant. The other related to the machinery for implementation and was closely linked to the supervision and control of the League. It corresponded to the securities for the performance of this trust, referred to in the same article. To answer the second issue, yes, the provisions of Chapter 12 of the Charter were applicable to the territory of Southwest Africa in the sense that they provided a means by which the territory may be brought under the trusteeship system, but did not impose on the Union of South Africa a legal obligation to place the territory under trusteeship. On the third issue, the court decided that the Union had no competence to modify unilaterally the international status of the territory. It repeated that the normal way of modifying the international status of the territory would be to place it under the trusteeship system by means of a trusteeship agreement in accordance with the provisions of Chapter 12 of the Charter. Moreover, the Union of South Africa itself decided to submit the question of the future international status of the territory to the judgment of the General Assembly as the competent international organ. In so doing, the Union recognized the competence of the General Assembly in the matter. On the basis of these considerations, the court concluded that competence to determine and modify the international status of the territory rested with the Union, acting in agreement with the United Nations. The question concerning the voting procedure to be followed by the General Assembly of the United Nations in making decisions on questions relating to reports and petitions concerning the territory of Southwest Africa had been submitted for advisory opinion to the court by the General Assembly. When establishing the Committee on Southwest Africa, the General Assembly passed Special Rule F, which established that its decisions needed a two-thirds majority. Since during League times, voting had been by consensus, the question was raised whether the new procedure was consistent with the 1950 opinion. The court first analyzed its 1950 statement that the degree of supervision to be exercised by the General Assembly should not therefore exceed that which applied under the mandate system. And the court ruled That Rule F, therefore, corresponds to a correct interpretation of the opinion. So that's it for part 1. Let me give you my co-presenter, Eunice Laure, for part 2.
Moving on to the admissibility of hearings of petitioners by the Committee on Southwest Africa and the Southwest Africa Cases Preliminary Objection. In the admissibility of hearings of petitioners by the Committee on Southwest Africa, a question arises as to whether the request for the court's opinion relates to the authority of the Committee on Southwest Africa to grant oral hearings in its own right or only under authorization of the General Assembly. After receipt of the opinion, the General Assembly, through a long series of resolutions, attempted to implement it. Subsequently, at the request of the General Assembly, two more advisory opinions were given by the court relating to implementation of the mandate. These advisory opinions, though they helped clarify the legal situation, were not technically binding on South Africa, and the conflict between the General Assembly and South Africa concerning the mandate grew sharper. Finally, the Assembly, by resolution, suggested that member states might bring a contentious case against South Africa under the terms of the mandate. In response to the suggestion, Ethiopia and Liberia brought the present action. In its objections, South Africa submitted that by reason of the dissolution of the League of Nations, the mandate for Southwest Africa is no longer a treaty or convention in force within the meaning of Article 37 of the Statute of the Court. This submission being advanced with respect to the said mandate agreement as a whole, including Article 7 thereof, and in any event with respect to Article 7 itself. Article 92 of the United Nations Charter provides that the court shall function in accordance with the statute of the court, which is an integral part of the Charter and is annexed thereto. Article 37 of the statute of the court reads, whenever a treaty or convention in force provides for reference of a matter to a tribunal to have been instituted by the League of Nations or to the Permanent Court of International Justice, the matter shall, as between the parties to the present statute, be referred to the International Court of Justice. Thus, the statute provides for transition of jurisdiction from the former court to the present one. Secondly, neither the government of Ethiopia nor the government of Liberia is another member of the League of Nations as required for locus standi by Article 7 of the Mandate for Southwest Africa. The second objection was that when the League ceased to exist, all the member states necessarily lost their membership, and today there can be no member of the League. However, the court said it was to effectively protest the sacred trust laid upon the League that the mandates expressly provided for invocation of Article 7 by any member of the League. To read Article 7 as South Africa suggested, the court reasoned would be to vitiate this essential judicial protection and would be incompatible with this spirit, purpose, and context. Of more significance, continued the court, Article 7 remains applicable today because the members of the League agreed that it should remain applicable. It was their common understanding that the obligations of the mandatory powers and rights of the League members should be continued so far as was practically feasible. Thirdly, the conflict or disagreement alleged by the governments of Ethiopia and Liberia to exist between them and the government of the Republic of South Africa is by reason of its nature and content not a dispute as envisaged in Article 7 of the Mandate for Southwest Africa, more particularly in that no material interest of the governments of Ethiopia and or Liberia or of their nationals are involved therein are or affected thereby. South Africa contended that dispute, as used in Article 7, means a disagreement or conflict between it and another member of the League concerning the legal rights and interests of such other member, and that although the members, by virtue of their status in the League, are entitled to participate in the supervision of the mandate, they have no individual right or interest in the observance by South Africa of its duties to the inhabitants. But the court said that the language of Article 7 of the mandate is broad, clear, and precise. It refers to any dispute whatever relating to any of the provisions of the mandate, whether the provisions relate to the obligations of South Africa toward the territory's inhabitants or toward other members of the League or to its obligation to submit to supervision by the League. Finally, the alleged conflict or disagreement is as regards its state of development, not a dispute, which cannot be settled by negotiation within the meaning of Article 7 of the Mandate for Southwest Africa. South Africa submitted that there have been no negotiations with a view toward settlement of the dispute. The applicants replied that repeated negotiations have taken place for more than 10 years under the auspices of the United Nations, and each time the negotiations have reached a deadlock due to conditions and the restrictions placed upon them by South Africa. In this light, the court, feeling that the chances of success would be slight were there to be further negotiations between the present parties, concluded that a dispute now exists and is the same dispute which has been negotiated before the United Nations without success, and the impasse which was reached there continues to exist in the present case, so long as both sides remain adamant. And this is obvious even from their oral presentations before the court. There is no reason to think that the dispute can be settled by further negotiations between the parties. The essence of the mandate system concept is that states which undertake to govern dependent peoples not a part of such states have a responsibility to the international community for the well-being of such peoples. The effect of the judgment of the court is to pave the way for a decision which, if favorable to the petitioners, will give legal impartiality to this concept and to the views expressed in the earlier advisory opinion of the court. The next two divisions of this Southwest Africa case will be discussed by Mr. Ayop. Mr. Ayop, you may take the mic.
The 99-page joint dissent of Judges Spender and Fitzmaurice was the harbinger of the 1966 judgment. So there were two major features are its legal technique and their conception to the United Nations and the court's role. The dissent features a positivism that presumes international law to exist in freedom from politics. So legal technique should keep the law from distant inherently normative determinations such as those apparently entailed by Article 2 of the mandate. The Wilsonian ideals underpinning the mandate system were present at the creation, though the contingency of the dissolution of the League was not addressed. The mandate gave authority to the Council and Permanent Mandates Commission, but nowhere stated or inferred that they were only implementing authorities. So, due to criticisms, Michael Reisman wrote in 1966 of the court's analysis on jurisprudence. So, he said that a jurisprudence which fabricates a distinction between law and policy and proceeds to apply the desiccated results of the distinction without judicial cognizance of the most intense expectations and demands of vast majority of the world is a retreat into mysticism. He also said that a jurisprudence which has so little confidence in the vigor of law that it must concern itself first with the purity of its own discipline rather than the functional and instrumental character of law in social progress can hardly serve the needs of a rapidly changing world community. A jurisprudence that can, in the name of law, reach a conclusion which against the moral and humanitarian principles that itself concedes is disquieting. And he also said that a jurisprudence which cannot grasp the inevitable subjective policy choice element in legal decisions but shuttles through the corridors of Aristotelian logic order to be forced to a conclusion which is non-consonant with community policy. He said that it lacks spleen which the modern world may properly demand from theories of law. So in contrast to the 1962 judgment, Dixon had faith in law as a progressive force. So it is an error if it is believed that the technique from the common law cannot meet the demands which changing conceptions of the justice and convenience make. The demands made in the name of justice must not arbitrary or fanciful. They must proceed not from political or sociological propensities, but more deeper, more ordered, more philosophical, and perhaps more enduring concepts of justice. So this should be the same as to be applied to international law. So in the 1966 judgment, on President Spender casting, the majority votes comprising judges from other different countries, they overruled the 1962 majority and dismissed the case for lack of standing. So the issue was that whether the judgment has not foreclosed this possibility, was it not res judicata? So the court in 1966, conscious of what had been decided in 1962, so they introduced a distinction. In 1966, the court sought to explain this effective reversal by saying to hold that the parties in any given case belong to this category of the state specified in the clause, that the dispute has the specified character, the forum is the one specified, is not the same as the finding existence of a legal right or interest relative to merits of the claim. So, but it must be the same thing. For one, categories of the state specified in the clause are presumably those who have legal interest in carrying the mandate. Moreover, the court in 1962 classified the applicants as falling within that category, not as an abstract proposition, but in relation to already existing and formulated set of claims. So it was also introduced that what are the conduct provisions and the interest provisions. So it said that conduct provisions were those like in Article 22 of the Covenant, which require mandatory to act certain towards people living in the mandate. So these are also requirements to conduct derived argument run from the sacred trust, while rights and interest provisions, which these are which protected certain material interests of other members of the league, such missionary activities. So the role of institutional legal order. So one response to this institutional distinction came from Judge Koretsky, who framed the contentious proceeding not as an instance of interstate dispute, but as a progressive by which the alternative control organ of the mandates court should be brought into action. On this view, the state was endowed with a right of judicial initiative within the limits of the Article 7. So another reflection to this was that on the institutional issue came from Judge Jessup. He quotes a quotation from Arnold McNair. So he said it was said that there was no perhaps part of the covenant that called forth more derision from the cynical and worldly wise mandates contained in Article 22. So the mandate system represents eruption of idealists into one periodical settlements which has spanned so to the so-called practical men. So in political fallout from 1966 and the 1971 advisory opinion, the General Assembly made sure that no white Commonwealth was elected. The court was institutionally sidelined from the United Nations system. The court responded in its terms, at least tacitly, the famous erga omnes passage in Barcelona Traction. So what was that passage? So there was a passage that in view of importance of the rights all states can be held to have legal interest in their protection. They are obligations erga omnes. So what is erga omnes? So erga omnes, such obligations derive, for example, in contemporary international law, um, from the outlawing acts of aggressions and of genocide, as also from the principles and rules concerning the basic rights of human person, including protection from slavery and racial discrimination. So in the 1971 advisory opinion in determining the legal consequences of South Africa's continuing presence in the Southwest Africa, the central question was whether the United Nations had validly terminated South Africa's mandate, thereby making the latter's continuing presence there unlawful. So the General Assembly resolutions are generally not binding, but the advisory opinion held that in specific cases, such resolutions can make determinations and have operative design. So they also held that the General Assembly terminated the mandate, that evidently this was one of those specific cases. So as for the basis of Judges Zafrullah Khan and other judges, it was institutional transfer logic development in 1950 opinion. So they also said that if the General Assembly was effective successor of the League of Council and the latter had the power to revoke mandate in the face of a serious breach as necessary part of its supervisory powers, so did the General Assembly. So the advisory opinion also includes a following passage. So this was the passage. So under the Charter of the United Nations, for their mandatory pledge itself to observe, respect territory. So it is to establish instead of enforce distinctions, inclusions, restrictions, and limitations. So on the grounds of race, color, descent, or national ethnic region, which constitute a denial of fundamental human rights, a flagrant violation of purposes and principles of this charter. So in conclusion, notwithstanding advisory opinion, the South Africa held out against increasing international consensus on Southwest Africa. So they eventually led into a negotiation and independence of the following territories, and also Namibia was admitted to United Nations on April 23, 1990.